here at the chamber.
Recording in progress.
Good morning, everyone, and those who joined us in person at the chamber, and those who joined us online. We're very pleased this morning to offer a discussion Q&A on the Corporate Transparency Act legislation that the requirements that we'll be discussing today took effect on January 1, 2024. The good news is there's time. I believe it's the beginning of 2025 or the end of 2024 to file the necessary report. We have with us Peter Murphy of Saul Ewing. Saul Ewing is a longstanding and very supportive member of the Newcastle County Chamber of Commerce. Our chair is a partner with Saul Ewing, as is Peter. And Peter's background is well suited to take on the role of leading the charge on the Corporate Transparency Act for Saul Ewing. He has a lot of experience in regulatory compliance in a arguably even more complex area, cannabis law and regulations. Prior to joining Saul Ewing, he was the chief legal officer for a company whose manufacturing, cultivation, and retail business spanned 3 states, pretty complicated jurisdictions for this. So we're very pleased to have Peter with us this morning, and I'll invite him up to the microphone. And thanks, Yvonne Detweiler, our interim president, and Elise Borlato for helping to bring this to our members. Thanks.
Thanks, Joe, for that introduction, and thank you for the chamber for giving me the opportunity to come present to you on the Corporate Transparency Act. So I've given this presentation a number of times for different audiences. What I'd like to do is really just get into some of the basics about what it is. Obviously, the deadlines is a big question, but then to really get into some examples of how it applies and how it can pretty quickly go from straightforward to kind of head scratching, right? And then I'd like to close with some questions, some discussion. I'll make sure we get time for that. So I wouldn't be a lawyer without a disclaimer. It always comes first. So this is being recorded, so I want to make sure the disclaimer gets out there. But this is not legal advice. You have questions about CTA, you should consult your counsel. I'd be happy to be that person if the situation arises. But this is also an area that is, as you can imagine, developing really rapidly. There's not a ton of guidance other than what FinCEN has put out to date. So it's an area that you can expect will be changing. So here's what I'd like to cover. Basically, a little bit of background on the CTA, the who, what, how, and when, the penalties for non-compliance, some examples for the simple to complex, and then also some practice tips and what I like to refer to as good corporate hygiene. And the CTA is really going to force that, I think, with a lot of companies, is that all of us are going to have to get a lot better about how we document things and how we stay compliant. I like to give what I call the bottom line up front. This is, rather than go on and on with lengthy slides, at its simplest, the CTA is all about connecting entities formed in states to people. That's it. They want to make sure that every entity out there with LLC after it or corp after it has an individual with a pulse that they can contact. And of course, being the law, being legislation and regulations, you're going to have very specific definitions. So the more precise version of that is that the CTA requires all reporting companies to identify their beneficial owners and their company applicants. So those 3 terms are really what drives the whole CTA and the rules that FinCEN has issued. So it's this question of whether or not an entity is a reporting company, whether or not an individual is a beneficial owner, and who the company applicants are. So as we've learned in going through this, these questions aren't, easy calls sometimes, and they do require advice from counsel and analysis of really where this individual falls and where this company falls and whether they have to comply. So as promised, a little bit of background. So the CTA establishes uniform beneficial ownership information reporting, a lot of adjectives there, for certain business entities. The whole point behind the CTA is, a lot of people say it's a long time coming because internationally, most countries have laws in which corporate transparency, corporate disclosures are required. The U.S. Congress passed the CTA really to close some of those gaps in what they call AML and CTF, which is anti-money laundering and counterterrorism financing framework, which was due to states don't really collect this information. A lot of states, if you file a document, you file a document creating an entity, you have an incorporator, you have a registered agent. There isn't a whole lot of collection of beneficial ownership information. So the goal was to collect this information and provide it to federal agencies for national security, intelligence, law enforcement purposes, and also to financial institutions. So where does it go? That's one of the first questions I always get. So FinCEN is the Financial Crimes Enforcement Network. It's a bureau of the U.S. Treasury, and they've created this, what they're calling, there's going to be acronyms throughout this whole thing. So that's the nature of the federal government. So they're creating something called the BOSS system, the Beneficial Ownership Secure System, that receives, stores, and maintains BOI, beneficial ownership information. So it's a non-public secure database, not quite at the level of classified, but about as secure as you can get before something becomes classified. It's cloud-based and it's managed to limit access. It's already operational as of January 1st. It became active. Filings are being made. Last time, I think on Valentine's Day, I read an update where there was about 450,000 filings made so far, which some people are like, wow, that's quite a few over a month and a half, but really they're expecting 32 million filings this year. So that tells me that the faucet is dripping at this point. We really don't have the volume that we're going to have later in the year. So who has access? U.S., federal, state, local, and tribal government agencies, foreign law enforcement agencies, financial institutions, and the U.S. Department of Treasury. Now, these aren't just carte blanche access, okay? So some of these either require a court order, they require consent of that person who owns the information. But generally speaking, these are the groups that will look to access the information. So who needs to report? So the first term I put up there, reporting company, that's really the question here too. Who is a reporting company? And reporting companies can be either domestic or foreign. But the key thing you got to remember is if the entity was created by filing a document with the Secretary of State, whether it's Delaware or some other state or Puerto Rico or any territory within the United States, it's a reporting company. So that's the key moment where there's actually a filing of a document to create the entity. Now, if it's a foreign company, it's also the filing of the document, but it's not just created, it's to register it. So it's a foreign entity that's registered in New Jersey. That action of registering it to do business in New Jersey turns it into a reporting company. So there's a few types of entities that don't do that. So things like sole proprietorships or general partnerships, private trusts. They're generally not going to be reporting companies, but it would be a mistake to kind of end the analysis there, because as I'll explain as we go through some of these, not being a reporting company doesn't mean you don't have to worry about CTA. It just means that you don't have a responsibility for filing a report. You could still end up being a beneficial owner. So you could have a situation which is a private trust. It doesn't have to file a report, but it owns an LLC, and the trustee of that LLC might be the beneficial owner. Okay, who does not need a report? This comes as some relief to people because there are 23 exemptions, 23 categories of entities that do not have to report. By and large, we're not going to go through all these, just that would be torture. But by and large, they're highly regulated entities. They're banks, public companies. And the reason being, they already knows, the government already knows the information on these entities because they're regulated. Where we're going to see a lot of activity around the exemptions are these two that I have in blue, the large operating company exemption and the subsidiary exemption. And so I'm going to spend just a slide or two on those because so far in my practice, what I'm saying is that's what we're doing a lot of analysis. Companies, they know they don't fit any of the other ones. It's an easy question, but these two, they might. So the large operating company exemption is for any entity that employs more than 20 full-time employees, files federal income tax return demonstrating over 5 million gross receipts for the previous year, and has an operating presence in the US, a physical office in the US. So if all three of those criteria are met, it's considered a large operating company and it doesn't need to file. So we're,
Question,
yeah, go right ahead.
if, let's say they don't meet the 5 million gross receipts, but they have 20 full-time employees, then they have to file.
Correct. Yeah, you gotta be 3 for 3. You could have 19 employees and meet everything else. You gotta meet all 3 of them. The second one I mentioned is the subsidiary of an exempt entity. And this is in those situations where you have, let's say, a public company, right? It's clearly exempt. And it has a bunch of subsidiaries that it wholly owns and controls. Those subsidiaries are going to be able to benefit from the subsidiary exemption. But the key here is that they're controlled or wholly owned by that exempt entity. There's a lot of situations in which it's a joint venture or there's different ownership structures, and this won't apply. It also doesn't work, it works downstream, it doesn't work upstream. So if this LLC, let's say, you have, they're all LLCs, and this LLC owns these 3. This one might be exempt for some reason. It doesn't automatically apply to the parent company, right? It flows down. And we're going to get into some examples a little later. So what needs to be reported? There's 3 areas of information. There's information on the reporting company, that is the entity that is not exempt and needs to file a report. Then there's information on every beneficial owner. These are individuals. And then information on every company applicant, which are also individuals. So reporting company, and when we actually get to what do you have to turn over, it's not that complicated. It's fairly straightforward. People may not want to do it, but really the challenge with the CTA is it's stale, right? It's that suddenly, all of these non-exempt entities have to turn over all this information. The information itself is not incredibly challenging. It's really the legal name of the entity, any trade or business DBA, complete current address of the principal place of business. Now, this is already, there's many questions out to FinCEN right now. They've been issuing FAQs all the time. And this is one that's already come up where you have a situation where you have an entity that's a US entity, but in this sort of virtual world, they might not even have a US address. And you can't put your registered agent on there. They're not your mailbox. Quick plug for all the registered agents. They don't want you to do that. But the question has already come back to FinCEN. Well, what if they don't have a US address? So we're waiting on an answer for that. The state of formation or foreign registration and a tax ID number, usually an EIN. For the individual beneficial owners, similar information, but it takes a little turn here at the end. So you have the full legal name, date of birth, and then a complete current address of the individual's residence. And here's where people start to, perk up a little bit because now we're actually connecting those 2 things, right? We're connecting an entity to a person and their residence. And then the last is a unique identifying number, which really is another way of saying it's a number that's provided either on a driver's license or a passport. US passport, if you have neither, it can be a foreign passport. And then an upload of that actual document. So here's another thing where we're really connecting that entity with a human being who has ID, and there's a copy of that ID on the system. So that should raise a lot of questions about PII, personally protected, personally identified information, and we're going to get into that too. So who's a beneficial owner? There's really two prongs to this test. So a beneficial owner isn't everyone that owns any piece of the company, but it can be someone. This might sound counterintuitive, but it can be somebody who doesn't own any, which is very strange, right? So you have these two tests. Either it's a person who exercises substantial control over that reporting company, or somebody who owns and controls at least 25%. And we're going to break both of these down, but keep in mind it's an or, and that's significant because FinCEN has said there should be a individual, a person connected to every single entity. There should be no circumstance in which a reporting company doesn't have a person that they can identify. So what is substantial control? There's four sort of bright lines that the rules give us, but the easiest one is senior officers: president, CFO, general counsel, CEO, COO, or a similar function. You might call it something else, but that's what they do. They're in charge. That's the senior officer. What's not on here is treasurer, secretary, vice president, and FinCEN has provided comments to the rules that say those tend to be more administrative in function. Really, the focus is on sort of the C-suite and presidents. Additionally, any individual with authority to appoint senior officers, or, for example, to appoint the whole board. So you might have somebody who's a minority shareholder, but for some reason they have incredible power when it comes to picking the board, picking the officers. That would be a person who has substantial control over the entity. Important decision makers. And this is where things start to get a little vague, right? This is where I feel like FinCEN was kind of like, just include everybody. But because, all right, so it's important decision makers, and there's three categories that they talk about. And then they finally just give up and they say any other form of substantial control. So it's very broad. And this is, again, where you come back to like, maybe I need some legal advice in deciding whether this person is in or out. And so far in working with clients through this, I find it tends to be a bit more straightforward. If you have, it's going to obviously be the senior officers. If it's not, it's then a person who by some mechanism has ultimate authority. And usually the entity is set up in such a way, it says, okay, well, so these people are going to have these roles, but I get to veto everything. Well, that's going to be a person who has substantial control. Who is a company applicant? This one is sort of falls to the back burner because it's just not as it doesn't get your attention the way the beneficial ownership stuff does. But for lawyers like us, this is actually really significant because a company applicant is the individual who filed the paperwork to create the entity. And that's another piece of this whole CTA plan is like, we not only want to know the person connected to this entity, but we want to connect maybe a few other people, a few other organizations that were involved in creating it. And the whole idea here is to find bad actors, right? So if you can find, who was responsible for creating all these entities that ended up into some, terrorist financing or money laundering or whatever it is, you have now a thread that you can pull on to hopefully do more investigative work and learn more. So for law firms like ours that help clients with formation of new entities, this is really important. But it could be the same as a person who goes on to LegalZoom and creates their own LLC, right? They're technically a company applicant because they are either the individual who filed the document to create the entity, or they're the individual who directs or controls the filing. Go ahead.
So I have to ask this question. This is crazy. What happens if your lawyer has recently passed or maybe left the company?
Yeah, so it's a good question because first, this only applies going forward from January 1st. But your question still is valid in the sense that it could have happened, a month ago. And so it's always going to be one person and at most two is kind of the rule. So in a law firm setting, it could be the attorney and the paralegal that did the filing. If you used an outside formation service like CT Corp or something like that, it would be a representative of CT Corp and the person who directed them to do it. There will be situations in which, you know, the person has passed or is just no longer available. What we're recommending is that anytime we form an entity now, it's imperative that we find out quickly whether that client wants us to do any CTA related work for them. Because if they say no, that's fine, but we just need to make sure they have our company applicant information so they can do their own report and put it on there. So it's the same information that beneficial owners have to give. So your ID, date of birth, except you don't need to put your residential address. You can use the business address, which is what we recommend. Yeah, go ahead.
Just quickly to clarify, did you say that you don't need to put the company applicant if your company started January 1 or up to now, or that's?
Oh, no, previously. So if the company was formed before January 1st, they don't need to provide company applicant information, which is, thank God, because we would have to go back and figure out who formed all of these entities. And I think FinCEN realized that was going to be, I mean, it's already going to be a challenge, but that would have been a nightmare. Sure. Okay. So I said I get to deadlines. So any entity created before January 1st has to file on or before January 1st of 2025. So they have the full year. Companies created after January 2024 have 90 days. This was originally supposed to be 30 days, but it got late last year. FinCEN agreed to extend the deadline. So they have 90 days. So if theoretically you formed an entity on January 1st, your due date is March 29th. And we're working with clients who, yeah, that is the earliest possible due date, and we already have some that are due that day. So it's a rolling date though, right? So it's 90 days from the creation of the entity, or getting notice of the creation of the entity. So it's not an annual report. It's one of these things where it's formed, you have 90 days. The 30-day deadline still applies when there's either updates or, so something like your company was exempt, you had 22 employees, you met the large operating company exemption, but then, you know, midway through the year, you're down to 10 and you're no longer exempt, you have 30 days to file a report. I touched on this in the last slide, but yeah, updates. This is where I think the CTA kind of takes on like a whole new life, because while you don't have to update this annually, you have to update it anytime there's a change in information for the reporting company or a beneficial owner. Which I had to read that a couple times the first time, because I'm immediately thinking, okay, the CEO resigns or the CEO, you know, retires and a new one comes in. That's a change in beneficial ownership information. A client does a transaction with another entity and the ownership coming out of it is totally different. That's a change that will require an updated report. We qualified for an exemption, we no longer do. That's a change. So the amount of updates, I think, is going to be massive. But also the question is, well, how do you stay on top of that? I mean, I, as a lawyer, am not going to be checking people's expiration dates on their passport, right? To make sure, and I don't think they want me to, but to make sure that they don't need to update it. So it's going to be something where if it's a law firm that's helping out or whoever it is, they're going to need to stay on top of that. And that gets to this corporate hygiene piece that I'm going to close with, but it's really forcing us to be much more vigilant about updating our information and knowing, you know, who owners are, what changes are happening, and keeping accurate records of it. So, was there another? Okay. So when it comes to corrections, as I said, there's 30 calendar days after you become aware to file a report. That was with updates, but it's the same for corrections. And there is this safe harbor. So there's a safe harbor from civil and criminal liability for voluntary corrections within 90 days of your submission. You submitted it, you look at it again, or you have somebody else look at it and they're like, no, that's incorrect. You can make that change within 90 days and not have to worry about any sort of penalty whatsoever. And again, FinCEN FinCEN wants to encourage compliance. Go ahead,
Who's
Gene.
tracking if you're correct or not? Like, who's tracking the CEO left? Like, how do they know?
You're right. I think the enforcement side of this
Yeah, that's a great
is
word.
hard to wrap your head around, right?
Yeah.
Because, and I'm not, yeah, all right, I encourage compliance no matter what. Let's just get that out.
That is recorded.
But I do wonder, like, if I were looking for companies that had never filed reports, where would I even start? Would I have
Yeah.
to start with the state and look at who created and then go like, it does there? I imagine AI is going to be somewhere involved in this, but it is a great point, and I haven't quite figured out how that gets monitored.
Peter, would a good analogy be perhaps, although maybe there won't be audits, or one would hope there wouldn't be, but IRS enforcement, sometimes for a year, it's not an issue until it is.
Right. Exactly.
And that's why you encourage compliance.
Yeah, and I think it's one of those extra hooks too, right? So if there's some other issue and it forces, an investigation into, have they complied with CTA? Now, that might be an added element of the investigation or that sort of thing. But that's a good point, Joe. All right, so what are the penalties? So for civil penalties, not more than $500 per day, which adds up. Where things take, and liability applies to obviously the reporting company, but then to those, to the individuals, it's all the way down the chain, right? So it brings up the situation of what if you have an officer, somebody with substantial control who's just not cooperating, they're just not turning over their information. The reporting company is going to definitely, be the primary liability there, but it will flow to the others. And then, at its maximum, fines of not more than $10,000 and not more than 2 years in jail or both, which, if you're gonna end up in prison, hopefully it's you don't want to be the guy there for CTA violations. All right, so let's do a couple examples. I had a little fun with that, but here's the simplest one, right? So a single member LLC, and frankly, in these cases, if somebody reaches out to me, I say, you can definitely do this on your own. You don't need to hire me to do it. Simply because it's that straightforward. So we'll take this example of Murphy Farms. It has 5 employees, 1.5 million in annual gross receipts. And Mrs. Murphy, my wife, is the 100% owner and president. So it's a reporting company. It doesn't meet any of the exemptions, not the large operating company exemption, no other. Mrs. Murphy is the sole beneficial owner because she owns more than 25%, which is the one prong. And also, because she substantially controls it, she's the president. So that's like the easiest one you'll see. So add a layer, or at least add some more people to it. So you have a multi-member medical practice. Doctors A through D and their ownership is the percentages underneath that. So if you break this down, or if we take as assumed, so doctors A and C are the managers in the medical practice. They're responsible for the day-to-day affairs and key decisions. Doctors B and D have no management or voting rights. The medical practice has 6 million in gross receipts, 23 full-time employees, and a physical office in Toronto, Canada. So the medical practice, despite having enough employees, enough gross receipts, is a reporting company because it's in Canada. It needs an office in the US. So because of that, it doesn't qualify for any exemption. So then we take it that next, so that's always the first cut, right? The reporting company level analysis. Then the second is, all right, which one of these people has to actually disclose? Well, Dr. A has over 25% ownership, so that's an automatic. Plus, Dr. A also manages it, so they have substantial control. Okay, Dr. B doesn't have any management, but has over 25%, so Dr. B has to report. Dr. C has less than 25%, but is one is one of the actual managers and responsible for the practice. So Dr. C would have to report. The only one who escapes here is D, who has neither management rights and is below 25%. So it gives you a sense of like, even in a simple structure like this, analysis is going to have to be done to figure out who's reporting and who's not. And then the last one, I'm not going to go through this, but I wanted to use it as right. And this is, believe it or not, this is relatively simple. But I wanted to give you a sense of like, here's a sort of real estate management structure, relatively simple. And you have these situations where you have managers of LLCs who don't own any of it, right? But they're going to end up being a beneficial owner and again, it's a search for the individuals, right? So that this question of, let's say each one of these entities is its own reporting obligation. And finding the beneficial owners for each one involves this search for the individual throughout the chain. So if, let's say we, filed a report for this one, we're now moving on to this one, we're still looking at, okay, this is the manager of that, which owns that. But, oh wait, we got a trust up here. It's, as I said earlier, that's not a reporting company, but we don't really care for this analysis because that's the beneficial owner. So we want to know who the trustee is, and on it goes, right? So you can see how it quickly expands from, Mrs. Murphy and her farm straightforward to an actual, real undertaking that's going to require some time. And leaving a scenario like this until, last week of December is not going to be fun, right? You want to get out ahead of these. That question?
Yeah, I guess kind of back to your second example there, if more than one human, I guess, meets the reporting requirements, are you required to report all three, or is doing one, does that satisfy the law?
It's all individuals that meet the beneficial ownership criteria. All right. I threw this in here, and I'm not going to go word by word here, but it's just to keep in mind that there are impacts beyond the reporting companies, right? So for instance, let's say I'm a bank, I'm a lender. I'm already exempt under the CTA. Like there's an exemption for banks, right? But that doesn't mean I don't care about CTA, because now I have to look at CTA as part of our due diligence process. I got to think about CTA when we're loaning money and what we're going to require from borrowers to make sure they're compliant. So CTA really becomes a component of really a lot more than simply, oh, am I or am I not a reporting company, or do I have to file? It really works its way into a lot of, really across a lot of industries, a lot of areas.
Very good question. If you're applying for money from a bank, do you have to supply them with your CTA documentation, or do they, because you, at the beginning of your presentation, you said how it's not classified, but it's also not readily available.
Correct, yeah. So what I think we're going to see is banks are going to start looking at they have their own due diligence requirements, extensive, federal laws. CTA is now going to be a piece of that, right? So when they're asking for disclosures, so they can, when you open a bank account, when you borrow money, that CTA is now going to be a piece of that. But what's probably going to be in that paperwork is a consent from you that they can check your beneficial ownership information. That's going to be part of what their intake. All right. How am I doing on it? No, we're good. So a few practice tips, in thinking about CTA as this part of a much bigger compliance strategy. So the first thing is something called a FinCEN identifier. So FinCEN, perhaps realizing that people's personal information is going to be flying everywhere, despite best attempts to keep it secure, created what they call the FinCEN identifier. So if you're an individual or even an entity that is going to be on many, many reports, you can apply to FinCEN and get an identifier, almost like a social security number, but with FinCEN, that you can use going forward. So I have one because I create entities and I'd rather not give out my driver's license every single time, right? So it's a way of, it's specific to that individual, and it's it eases the whole administration of it, but also protects your information from constant disclosure. Now, you got to protect the FinCEN number too, right? It identifies you, but it's there to help.
Sorry, I just wanted to clarify. You said that you don't need to provide your social security number in order to,
You do not.
okay.
No, yeah. So the pieces of information are name, date of birth, residential address, and then your ID, basically. Or passport, right? So this allows you to provide that at the outset, get a number in return, and then use that number going forward.
What happens if your driver's license expires or something, or your passport? Like, honestly.
No, you're right.
these are
No,
things
it's a
like-
great, because right when I got my FinCEN number,
Uh-huh.
I gave it to a pair, I was like, hey, I got one. And she's like, what's the expiration date on your license? And I was like, what? She's like, we're gonna have to, you have to update it, right? It has to be accurate. So I have, we have a log of FinCEN numbers and expiration dates of IDs, so we know when to update it. Again, it's forcing this level of, of call it hygiene or whatever that is, it's onerous, but I think it's going to become kind of the new normal, just to stay compliant. All right, privacy concerns. Obviously, we've been talking about personal identifying information. This is more like really bringing front of mind things that have been that way in other countries, much like CTA, the protection of private information. Every time you go on a website and you see a thing for cookies or whatever it is, that's just an example of how that's going through all of the world to make sure that we're safeguarding private information. So FinCEN, it does, people have said to me, doesn't this whole system present like the biggest cyber target ever? And I think, yes, it does. It collects a lot of valuable information in a single location. But, the IRS is another example where we have similar storehouses of personal information. Preparing for future disclosures. So this is, again, to that point about the bank and its consent forms and due diligence. We're already in the process of updating a lot of our contracts, operating agreements, things that are going to require CTA compliance. So for example, you form an entity, it has a bunch of founders. You're going to want in that operating agreement a representation that everybody's going to cooperate to comply with CTA. You're not going to withhold information. You're going to provide accurate information. In the event that you provide false information willfully, you're going to indemnify anything that the company for whatever happens. So we're finding these are working their way now into a lot of form documents, model documents, adding consents, right? That you are willing to disclose, or consents in the bank example that they can access information. And really working it into, whether it's an annual sort of review or audit, or even going as far as saying, look, because this information is important, we don't want to have to collect it every year, require a FinCEN identifier, and then have the burden on the person to maintain that FinCEN identifiers, right? So you're not having a storehouse of everybody in the company's PII and with an assistant who's doing all this work. Rather, it's, hey, you provide your FinCEN number and you're obligated to keep it up to date. We kind of covered this already, but the due diligence process, standard reps and warranties, indemnity coverage for non-compliance. And this CTA as a negotiating lever, I mean, this comes down to sort of some people, I find in the cannabis world where I've done a bit of my work, some people's revealing of their identity is very important that they don't do it. It's a key consideration in doing a deal. So having, if somebody wants ownership over 25%, you're like, oh, okay, well, that comes with the disclosure to FinCEN. They might be like, I'll take 24. There's going to be no doubt a lot of effort to try to avoid disclosure, being a beneficial owner. Again, there's ways that you can do this legitimately by just, making sure that the person doesn't have substantial control and that they fall below 25%. But ultimately, owners are not gonna be able to avoid the connection. If they are an owner who has control over an entity, they have a reporting obligation, right? And even when it comes to, well, I only have 10% in stock, but then there's all these other contracts with, convertible notes and things like that. Finn says that all that counts. When you look at 25%, it's not just, membership units in an LLC or stock in a corporation. It is all mechanisms, even agreements in which you can get ownership if they vest. So it's really unlikely they'll be able to avoid that. Here's just some potential ambiguities. When you have a situation, I've already had this question frequently, which is, well, I sit on a board. Does that mean I have substantial control? And the answer is generally no, but if it's a two-person board, then maybe, but Vincent has said that sitting on a board alone is not de facto substantial control. Being a senior officer, a CEO would be. What about situations in which voting and where control and ownership actually are sort of flipped, right? You have somebody who has a veto right. They're a minority shareholder, but they have a veto or approval right over important decisions, but they only have 5%. Well, applying the substantial control rule, they would be a beneficial owner. And then vice versa, you have somebody who has no voting rights, no control, but they own 50% of the company. They would also be a beneficial owner.
Can I ask you a quick question?
Sure.
So, there's a lot of, community pools out there where you have to buy, or even like a co-op where you have to buy ownership. Does that also mean this?
So the first question there, I would start with, is that a reporting company? And one of the exemptions, are nonprofits. I don't know if your example would fit.
They're nonprofits, but they're not 501(c)(3).
Right, so they actually would be reporting companies. Odds are a membership in a co-op would, you probably have nowhere near 25%, so you wouldn't reach that level. But again, if you're the president, if the co-op is, an LLC and you're the president, it's a corporation and you're a senior officer, then yes, it would be a beneficial.
Peter? Yeah, pardon me. The C3 exemption is kind of like, top line, but are you saying that it wouldn't apply in the C4 or C6 context?
So the rule says 501(c). Actually,
501(c).
C, just that, 501(c), registered nonprofits are a specific exemption.
Good, so it's not just three. Thanks.
All right, and then back to good corporate hygiene, record keeping. Again, this is going to force a lot of good habits, I think, in the end. It won't necessarily be pleasant, but in the end, we should have, much clear, and that's the whole idea, is that we have a clear understanding of who owns what. Now, the bad actors who are going to incredible lengths to hide their identity, I don't know if they ever file a report, right? And it comes back to your point. What about the entity that never files? How? And I leave that to FinCEN and figuring that out. But I have a feeling that their work with financial institutions is going to be a big driver of finding that money laundering shit. All right, so sort of final thoughts, getting the word out. No matter how much I've given a lot of these starting as of 8 months ago, and it's like, and I talk to the same people, and it's like the first time I've heard it, and it's amazing to me, because I think it's human nature, right? It's not until something's urgent with whatever. So getting the word out is really important, and that involves you can find resources supported accounting and law firms. I'm finding accountants generally, the legal questions that the CTA asks are a little too far for them, and they'd rather have lawyers weigh in on that. But the whole goal is avoiding this crunch in the fourth quarter that is in some ways unavoidable. It's going to happen, but getting out in front of it, particularly if you have a complicated structure, getting out in front of it, getting it done, and it's one less thing to do when the holidays come.
Is this website hard to get into, like a lot of the federal?
No,
websites,
this is
like-
actually, I will say, this is an excellent, FinCEN put together a very good website. And I would recommend checking it out. There's a lot of good resources on it. And in particular, the small entity compliance guide is, I think, very well done. It goes through in a very logical way, the process of looking at the reporting company, looking at exemptions, beneficial, all the way through. And I think for most small businesses, that's going to take them a long way. There might still be questions that they want some advice on, but that guide will be very helpful. And then FinCEN puts out these FAQs. They haven't put any out since mid-January, so they're kind of overdue, but hopefully they update that soon and answer a lot of the open questions.
Is it like tax forms where you can file the easy one or the hard one? And like for small businesses, you need a specific form, but once you start getting into 20 people, $5 million, et cetera, you have to file a different one?
No, but I like the way you said that in the sense of, I think the more complicated it gets, just like my own taxes, like it hit a point where I was like, and I needed help with it. I think this is kind of similar. As your organization gets more and more complicated, you're going to want that support. But as far as the filing itself, if you go to that website, I mean, one of the buttons is file your report, and it's all electronic. There is a PDF way to do it. I think they're doing it as just sort of an accommodation for people who are not comfortable with doing it online. But it is everything is there, and that's the portal in which you make the filing. All right, so I hope I left a little bit of time. We hit some questions as we went, but I'm happy to answer any others.
I actually do have a couple from the chat.
Sure.